Okay.
Rock and roll.
Well, I guess, yeah, we'll get started then. I'd like to thank you all for coming today to this presentation regarding remodeling contracts and practices. I'm Brad Dagan. I'm an attorney with Rosen DeYoung Law Firm. We're out of Milwaukee. We have 12 attorneys. We're a general business practice firm, and my practice focuses on business relations, corporations, LLCs, and that sort of thing. But as a big part of my practice, I represent quite a few contractors and subcontractors in the construction industry. I've been a member here at the MBA for more than 25 years, been on a number of different committees, and one of my best experiences was on the arbitration board, which has been revitalized in the last couple of years, so I'm going to make a little plug for the arbitration board. Ultimately, that is where one of my clients way back when suggested that I get involved with the arbitration process so that I could learn more about construction. And over the years, it proved to be a big help. First of all, I met a lot of great people and a lot of conscientious contractors who helped educate me as to the construction process, because going in, I didn't know a truss from a joist, and I knew what a nail was at least, but it was very helpful to participate in that process where we would go out and actually resolve disputes, see construction issues, listen to various builders, contractors, suppliers, and then also the customers. So over the years, became more familiar with the construction process, and then focusing in on today's topic, I learned a lot more about remodeling over the span of time. And one of the key aspects of remodeling, of course, is the fact that we're dealing with renovations or upgrades to an existing home. And as I mentioned in my outline, and one of the things that really pops out is the psychology of all of it, because I think in the remodeling process, one of the critical things, of course, is communication, but it's also trying to match or understand the customer expectations, and then to take those expectations and try to bring them into fruition, have a smoothly run project, trying to keep the customer happy, but also trying to make sure the project moves along at the same time. And I think one of the big things that we've seen is that some of our clients, while they're awesome builders and contractors, they aren't psychologists or psychiatrists, and that sometimes that's, as you probably all know, that's what you have to do, is become a psychologist or a psychiatrist. And I think that's particularly true when it comes to remodeling, because in large part, a lot of times, the customer will still be living in the home, and that creates, I think, increased anxiety on the part of the client or the customer. And then in my outline on page 2, I just mentioned a number of things relative to the things that are logical to do before the contracts are signed. My goal today is to kind of do a couple different things, is to relay some of my experiences and then also to tap you for questions. So feel free to ask questions at any time. Just raise your hand, please, and then we'll call on you and ask your questions. Feel free to interrupt. This is pretty casual or low-key presentation, so I have also found that your questions are hugely helpful in formulating future presentations, but also the input we've gotten from the membership has really helped to develop and improve our contract forms, which I'll also talk about today. So my primary goal is to talk about, number one, the remodeling process in general, also to focus on the administrative code provisions that apply to remodeling, and it's a unique set of rules that apply to remodeling projects only. And then to also talk about our contract documents that are offered here through the MBA, because I think those are very helpful and have been developed over years of experience, not just for myself, but a number of other contractors, other attorneys, and just the trades in general have had input into developing a contract that hopefully serves as a roadmap for a good and solid project. But before the contract is signed, there's a number of considerations. One of them, of course, is the psychology with the customer, and apart from developing price and scope of work, there's other things that I think are important to keep in mind too, is to prepare that customer, especially if they're going to be still living in the home, for what the construction process involves. A couple of the bigger things that we've seen over the years that customers bark about would be the noise, the dust, and then delays in subcontractors coming. Some of the customers don't seem to understand that suppliers or trades don't come to the house every day, that there may be gaps in the work. And that's one where we've heard a number of gripes over time. And then I think from the contractor's perspective, it's important to educate the customer, particularly when it comes to allowances and making selections. I'll probably focus a little more on that when we talk about the contract. But I think just in general terms, just understanding that this is part psychology and part building is an important consideration. One of the other things that I mentioned in point 7 on page 2 is protecting the customer's property. One of the things that sometimes gets damaged, apart from personal property, would be landscaping and exterior plantings and that sort of thing. Sometimes the customers don't understand that that may or may not be, a restoration of landscaping may or may not be included in the contract price. So it's important that they understand that if there's going to kitchen expansion, for example, that takes out a couple of bushes and tears up the lawn a little bit, that sometimes that restoration may or may not be included in the contract price. So that's something to discuss with the customer ahead of time before the contract is entered. Again, too, if the customer is living in the home, try to explain to them the entire process and explain what they can expect relative to construction, and particularly the dust and the dirt, and the fact that they might be confined to live on only a part of the house. Sorry, I'm fighting some allergies, so we'll work through that. One of the important things to keep in mind in remodeling that doesn't apply to new home construction is Chapter ATCP 110 of the Wisconsin Administrative Code. I think we handed out a copy of that to everybody, and that is Wisconsin's response to the tin men of the 1950s who would sell aluminum siding to people, take big deposits from a number of people, and then basically move on to the next town without actually doing any work. Over the years, this has been expanded to include remodeling projects in general, although a recent revision is helpful, I think, where it has taken out large projects, which are referenced on page 1. Let's see. The recent amendment took out its major renovation. I was looking for the exact words. Major renovation of an existing structure is no longer covered, and that is specifically defined as the total contract price exceeds the assessed value of the structure. Now that's assessed value per the tax bill, which is typically going to be lower than fair market value. So I think that will help the industry in general by taking bigger projects out from under the scope and some of the pitfalls that we see in ATCP 110. These rules of ATCP 110, I think, were drafted with good intentions, but at the same time, they provide a lot of specific detailed requirements that essentially can trap our contractors in case they have not followed some of the rules. Two of the bigger problems I see from time to time under ATCP 110 are the fact that a lot of our clients don't use written change orders. Basically, any change order that calls for the payment of money or there's an extra cost associated with it, technically under ATCP 110 needs to be in writing. There's a couple of other things too that I'll cover throughout the talk today about ATCP 110, but keep in mind that that's essentially governs two aspects of the remodeling process. The first is the contract. There's specifics, a part of ATCP 110 that provides that if you provide a written contract to a customer, there's certain requirements that must be in the contract. And that section is under ATCP 110.05. And I think we've got a few of the things highlighted that must be included under that section in particular in the outline, and I'll get to that in a minute. But I'm going to step back for a second too, because before the contract is signed, there's a couple of other rules under ATCP 110 that people, frankly, typically don't follow. One of them is providing a list of building permits before the contract is signed. Sometimes we don't even know what building permits we need, especially if unforeseen conditions arise. So it's kind of a catch-22. where I've advised my clients to put into the contract that they'll provide all necessary permits and then provide a list at some point, either in the scope of work or in some kind of detailed itemization before the permit is pulled, that the customer understands that a general permit is needed, maybe an electrical permit is needed, and a plumbing permit is needed, and that there's charges for all of that. Sometimes we put those under our allowance section, and I think in the contract documents, there should be a line item for that in the allowance area. But we'll, again, I'm kind of jumping around, but the main emphasis here is that the code provides two different sets of rules, one for the contract documents and one for actual practices. Now, typically, the honest contractors won't have a problem with this, but we sometimes see miscommunication among the customer and the contractor, and I think one of the biggest areas I see is in changes that are made on the job, and especially those changes that involve increase in prices. The other thing that we see from time to time that we'll cover as we go through the talk are the allowances in particular. Sometimes the customers have different expectations as to what will be included in the project versus what the contractor had in mind when they quoted the project to the customer. For example, if a customer sees one of your remodeling projects or a new home, or provides you with a photograph of something that they want to incorporate into a remodeling project, they will frequently misunderstand what is included in the project. For example, countertops is a significant area, or tile is a significant area, where there can be a wide variety of price relative to countertops and tile. So sometimes a customer thinks they're going to get the most expensive thing out there when all that's included in the contract is some sort of base type countertop or a basic tile. And if they want an upgrade, they sometimes don't realize that that's going to cost them money. And that's where it's important to explain allowances. For the contract practices, time for performance is another big one. Sometimes when there are delays, there's miscommunication. R4 and what the ultimate new completion date will be. But again, I think I want to go back to my outline a little bit, and before the contract is signed, number one, the ATCP 110 does say you have to inform the customer about all permits before the contract is signed. Sometimes we put those right into the document, just specifying what permits are needed. The other place that can show up is in specifications or in your price quote, where you're itemizing what things are needed for the project. But again, any permits that are needed should be specified, and then also try to inform them of the anticipated cost of those permits. Then there's other things that are needed. Compliance with the financial responsibility law, that's the Wisconsin law. There's the certificate, the builder's certificate, where you prove up that you have liability insurance. You're supposed to make sure that the owner understands and has read the contract before they sign it. If there's any financing involved by the builder, that has to be disclosed in writing. One other thing that is supposed to be done before the contract is signed, but frankly I don't know any of my clients that actually do that, is to tell the customer that they're entitled to lien waivers. Theoretically, under ATCP 110, you're supposed to have a separate written letter saying, hey, as we make progress payments throughout the course of a project, if it's installment payments, say there's 3 draws, for example, you're supposed to tell the customer in writing before the contract is signed that they're entitled to lien waivers. Ultimately, we've looked at that issue and seen it come up a couple of times where somebody's tried to raise that as a technicality, and I think that in cases where the contractor actually provides all the necessary lien waivers before the project is done, the contractor is usually in good shape, even though it's not technical compliance with ATCP 110. At the same time, I think it's important that we understand that by the end of the project, the customer better have copies of all the lien waivers, because otherwise there could be some issue raised down the road that may not be particularly fair, but it's a procedural rule under ATCP 110 that can trap us if we don't provide copies of all the lien waivers. Frankly, there's been a couple of good cases lately under Wisconsin law that I think have helped us as a construction industry, where the courts have said, wait a minute, this rule of ATCP 110 is really strict, so in order for a customer to recover under that administrative code, there must be damages connected to an ATCP 110 violation. That's really helped us in that lien waiver example, just for example, because in that situation, if there's no harm, it's kind of like no harm, no foul. And that's been a nice trend in the case law, which 5 years ago we couldn't really say the same thing. There's a number of other things that come up too under ATCP 110, where if there's no damage to the customer, they can't recover under ATCP 110. And one of the biggest concerns I have about this law is that the consumer, under another aspect of Wisconsin statutes, is entitled to double damages and attorney fees in the event they can show a violation of ATCP 110 that has cost them money or cost them some kind of financial loss. So that's why we try to preach strict compliance with ATCP 110, but if there's no damages or if there's other means of showing that despite non-compliance the customer was not harmed, it's not so bad. But there are the other cases that I've seen where customers do end up with pit bulls for attorneys sometimes, and ultimately they will tend to try to litigate these things to death, but at the same time, in many of those cases we're able to negotiate or take the case to arbitration, which is another thing we suggest is always having an arbitration clause in the contract. So let's jump back. The written contract requirement, essentially the ATCP 110 generally requires, not in all cases, but what I'm suggesting is that you should have a written contract under all circumstances. Now we see a wide variety of writings that constitute contracts. Sometimes it's the one-page quote. Frankly, the one-page quote is usually not good enough to protect you both in the contract context and under ATCP 110, because under ATCP 110 there are a number of things that must be in the contract in order to be compliant with the rules. So I'm going to maybe just scroll through the remodeling construction contract, and this is an area too where, you know, I think everybody has a copy of it. It's 17 pages long, and at one time we had a contract that was 6 pages long, and unfortunately over the years we've kind of had it evolve into what seems to be a long document, but at the same time, as we go through it, and as you can go through it with your customers, if they understand that these protections are in there and the detail is in there to really not just protect the contractor, but it's also protecting the consumer because of the detail of the document. It helps explain what certain things are. It defines change orders, it defines allowances. Obviously, on page 1 of the contract, we need to identify the parties. Interestingly, a contact person must be in here, a specific name, not just a company name, and that's under the ATCP 110. I don't think that I've ever heard anybody raise that as a technical defect, but at the same time, that's what the rules say. We have to have some specific human being named in the document rather than ABC Company as the contractor. And as a general practice, especially for a bigger company, it's probably wise to have a contact person named for each particular project. The second part is the project description and location. Frequently, this is just a general reference, and a lot of times the details of the plan or the details of the project will be set forth in either specifications or plans or both. For a bathroom remodel, for example, typically we would expect to see cabinet drawings, and then ideally we would make that part of the contract, and also ideally you'd have the customer sign off on the cabinet drawings, because ultimately sometimes we see miscommunication or customers will come back later and say, oh, I thought this was included as part of the cabinets, or I was supposed to get 5 cabinets and I only got 4. But if they sign off on the drawings, that's your best protection against any kind of confusion down the road. Certainly the contract price is important. This form calls for a specific set price type of contract, although it does contain a reference for allowances and changes. I have a number of clients who do the cost plus arrangement, and I don't know if any of you do the cost plus arrangement for contracts, but those are acceptable, those are binding, those are enforceable. I think they're a little bit more difficult to manage, but I think I have a couple clients who exclusively use the cost plus form, and they have a pretty good system where they've developed where they get the bids from the suppliers and subcontractors. make a bid packet, show it to the customer, have the customer accept those bids or sign off on those bids as part of either a total price quote where the bids are attached, or ultimately, in one way, shape, or form, the customer gets copies of all of the bids. And then the general contractor's fee is tacked on later on, sometimes ranging from 10 to 20%. And obviously your business practice will dictate how much of a profit and overhead that you all would include in such a contract. But those are enforceable and binding. I think they're just a little harder to manage, but if you have a good office staff, for example, that can also be a successful way to conduct your business. Our form here at the MBA is focused more on these specific set price, like you give a price quote based upon your experience for a project. And sometimes maybe you will go out and get bids and include those in here, or it's based upon your experience. If you've been around for a while, you can bid out a job and say, I think this will cost about $25,000 to do a real nice bathroom remodel for you. So you can put that in here and give them a quote and then ask them for a down payment. And then of course we talk about progress payments. That's on page 2 at the top of the contract. That's effectively the draw schedule. Depending upon the size of the job, maybe there'll be draws, or maybe sometimes we have clients who have projects who will say, well, I want 50% up front and 50% on completion. All that would be laid out on page 2 at the top. Payment is very specific in paragraph 4. There's a blank for the number of days that the builder allows the customer to make payment. Usually I suggest to my clients that they put in 3 days or 3 business days in that line in paragraph 4 on page 2 of the contract. This details the customer's obligation. Once they receive a draw request, they have to turn it around and not sit on it within a certain period of time. Ultimately, we put in a penalty of 1.5% interest per month and reasonable attorney fees. Every once in a while, we've seen that have to be enforced, but generally it's nice to have that in there so that the customer understands that if they fail to make a timely payment or improperly withhold payment, this could be a tool used to kind of persuade them to get off their butts and sign the draw and make sure you get paid. Number 5 is allowances. We've broken that down between site allowances and selection allowances, and certainly I'm sure this group, just looking around, I'm sure you understand the differences, but the customers don't understand that. This is one area where we see a lot of questions from the customers because they may come in naive or may have not built before or may not have remodeled before. So they really need to understand what the allowance is. So it's particularly important to spend extra time with your customers and explain what an allowance is and what the difference is between a site allowance and a selection allowance. One of the other things that'll come up is unforeseen conditions, but we have a separate section that covers that. And section 6 is changes. That's the other area where we see the biggest number of concerns or questions. Within the change order area, it's pretty clear that Wisconsin law requires a written change order for any change that will cost extra money for a project. Now I've had a number of cases where changes are just done on the fly and we don't get a signed document. If you can get an email or a fax or even a handwritten note where the customer has approved a change in the scope of work and puts it in writing in one way, shape, or form and acknowledges the price increase, that's for attorneys, that's golden, because I think that's enough evidence to prove that the customer approved the change order, approved the dollar amount, and it's enforceable. Even if it's not technically compliant with ATCP 110, we've been able to show that that sort of methodology will be binding and enforceable on a customer. One aspect of that is a concern is whether or not verbal changes are binding. I think we have, I had a good question about that. What if the customer pays for a change order but doesn't sign it? Is that binding and enforceable? I think 99% of the time that will be, because even though a written change order was not signed, the customers paid for it, and I think that can serve as either a waiver or an admission that they knew that they were going to be charged more money. They paid for the change was put into place, and assuming the change was effectuated properly, the payment should hold up. One thing I've seen is, and I'm sure that everybody in the room has seen this at least once or twice, is if you're working with a husband and wife, for example, or business partners who are doing a remodeling job, ultimately, one example that I give is a master bathroom remodel that was about $120,000 in some fancy house in River Hills for one of my clients was doing. And the husband and the wife were generally in agreement on the scope of the work. They signed the contract. The husband traveled a lot for work, so the wife was kind of running the job. She decided partway through the job that she wanted to change the tile in the shower. It was like one of those two-person showers. And then in the tile job, she wanted like a mosaic pattern, like a butterfly pattern. Suddenly that added like $15,000 to the cost of the project, and the husband didn't know about it. She approved it. They went back and forth. There were a lot of emails back and forth on this particular increase, and she goes, oh, I know, and the emails actually said, I know this will cost me a lot more, but the error that we ultimately saw was that there was no agreement as to the price. So I say in my outline, emails are binding and enforceable, but it's key that in the emails you would have, especially for a change like that with the tile, you would say, well, this is what you asked for, this is what we're going to do, and it's going to cost you an extra $15,000. And had we had an email exchange like that, we would have been in really good shape, but we didn't have the price in there. So we had a meeting. This was ultimately a reconciliation meeting at the end of the job, and the husband didn't know about that, and he saw that at the end of the job, and he kind of had a fit at this meeting. And so it took us about 2 hours to sort through that topic alone. There were a couple other increases too that he kind of sort of consented to, because he must have talked to his wife about those, but he didn't know about this, so he was pretty mad, and she kind of backtracked a little bit. And so we had to, it took, like I said, it took 2 hours just to talk about that, and we ended up settling that at about 50 cents on the dollar. But my client took a beating. You know, he actually lost money because there just that one little extra bit in the email, and I know it's hard to get written change orders, and we also know that some of our subcontractors will be asked to do things by the customer, and sometimes they don't come back to the builder and stop the work and say, hey, can you get the customer to give written authorization to add like some extra can lights, for example, and that sort of thing. So the communication is key, and the emails, I think, are a wonderful tool for us to expedite, because now you can do things electronically, whereas in the past, if you had to drive out with a handwritten piece of paper with a change order, sometimes you lose time in your project, or your sub is on the job and you just tell them, oh, go ahead, we'll figure it out later. But the email will help us kind of reconcile all of that and make sure that the contractors get paid, and it also helps to make sure the customers are educated too, that they can't come back later on and say, oh, I didn't know that. But you have an email that says, hey, wait a minute, you approved this change, you approved the $15,000 extra for the tile, and so therefore it's binding upon the customer. I'm going to go back to the contract. That's page 3. Kind of continues with the change order discussion. One other area that comes up too is what happens if you do such a change. Can you still get paid if the change order is not signed? What if it's a purely verbal change order? That can be enforced under the rules. It's called, the rule of law is called unjust enrichment. But unfortunately, a lot of times, in order to get paid for that type of thing, you would have to get a lawyer involved who would explain to the customer, hey, you asked for this, you roughly knew what the price was. But going back to the tile situation, it was such a big increase in the price of the tile that it's going to be hard sometimes to prove unjust enrichment. And then a lot of times, unfortunately, because of the cost of attorney fees and the delays in time, sometimes the contractors will have to let that kind of stuff go, where it's just another way of recovering. Typically, we would not even pursue that unless the job was done, because one of the bigger rules of advice that I give to my clients is, no matter what happens with the customer, try to finish the work, get the job done, get off the job site, do your cleanup, and then try to sort out some of these issues later. Because there's two reasons for that. One is if the job is done, sometimes the customers calm down afterward and become more reasonable. The other aspect of that, though, is I've had a couple of cases where the customers brought in another contractor who will finish the work, and as we all know, they'll come in and charge double what really they should have charged, and then the customer will want to extract that price from you as the contractor, saying, well, you didn't do what you're supposed to, so I had to hire somebody, they charged me more, but too bad, I want that out of you, and I'm taking that out of the last draw I owe you. So those are, definitely over the years, in every case that I've seen through arbitration, cases I worked on as an attorney, I can't think of very few exceptions where, get the job done, finish the work, and try to sort out some of these issues later. Because at the end of the day, I think it puts the contractor in a better position to negotiate. And in the court system or before arbitrators, if you finish the work, you as a contractor look a lot better as well. And I think that helps favor, if there's any gray area, that helps tip the scales in favor of the contractor. There too, that's, I think that goes back to the psychology of the remodeling process, but obviously that exists in all aspects of construction. So as we flip through the contract, I was on the changes provision. The next up is the contingencies. Those are fairly typical, financing, and setting up a construction escrow for larger jobs. Sometimes we've had projects where an escrow is set up in a private bank account where 2 signatures are required. So if you have a customer who can pay cash for a job, I think it still makes sense to set up an escrow account so that you're not so much basically a victim of a customer having control of the purse strings. Ultimately, I've seen a couple cases where somebody said, well, I'll get that out of my investment account, it'll take 10 days, so we'll pay you, in a couple of weeks every time you submit a draw. I think the better practice is to try to get them to take the money out of their investment account and put it into a bank account where there's 2 signatures required, or at least that there's some control. And even in a case like that, we still use title companies where the money is deposited with the title company, because then there's a more objective process for getting paid. Or at least if it's a 2-party check, then the money is there, and if there's a dispute and it gets resolved, you'll get paid at some point in time. Insurance is important under Section 8. I'm sure Don Miller would agree with that, being the insurance salesman. But the insurance requirements, I think some of the customers don't understand what insurance really is. Typically, the contractor's requirement is for liability insurance, and those are issued under general liability policies. Sometimes the customer thinks that that's like an errors and omissions policy, and so that anything that goes wrong with the job is insured, and that's not the case. Errors and omissions insurance is expensive. It's basically, malpractice insurance for the construction industry. Some architects have it, some engineers have it, but typically builders and contractors and subcontractors don't have that type of coverage. So it does pay to just take a minute with the customer and explain that not only, you're providing general liability insurance, but importantly, the customer has to obtain insurance too. On page 4, we talk about the builder's risk insurance that the customer must get. That's very important from the contractor's perspective, because that helps protect the project, especially in the case of damage or theft to a particular project. So the owner should provide a certificate of insurance, and that's all provided for in Section 8 of the document.
Brad?
Yes, sir.
That's sort of a touchy area as far as the builder's risk goes. Builder's risk typically is, on a remodeling job, is going to take place if the remodeling job is fairly extensive, and you're putting, literally hundreds of thousands of dollars into the project, for example, an addition or something like that. If you're doing a kitchen upgrade or a bathroom upgrade or a rec room in the basement, for example, typically what the consumers, all the consumer needs to do is to increase the limit of their homeowner's insurance to include the new value of that home after the project was completed. So for example, if you're putting $100,000 addition onto a $500,000 home, the client then should simply up their homeowner's insurance to $600,000. And they do that prior to you starting the project. If it's a remodeling of an upgraded kitchen or upgraded bathroom, typically that's not going to tip the scale. Because it's almost like a maintenance kind of procedure in a home. And so that's not being required. But if you get into a project where there's an addition involved, or maybe an extreme project where, you know, it's almost a total home rebuild, and there the kicker is, if it's a project where the homeowner has to evacuate the premise for any length of time, whether it be a month, 6 months, whatever the case is, that's a red flag. Then you better make sure that there's that the owner of the home has done something to cover the cost of that project. And if they don't want to do it, well, you know, yeah, it can be their loss, but it can be your loss too, in the fact that you'll notice on the insurance section that, again, on a bigger project, that the homeowner's insurance, their homeowner's insurance, or even a builder's risk policy, if it goes that far, that they name you as a loss payee. What that says is, should there be a devastating loss, and now you've got, maybe you personally, you've got $30, $40, $50, $100,000 of time and material into that home prior to the loss, you know, tornado, fire, whatever the case is, that you now have access to cover your out-of-pocket for what's been destroyed. In other words, you know, you meant to take that draw out on Monday, but you didn't do it, and now there's a lot of your cash hanging in there. That's what naming you a loss payee covers. So they can't cash that claim check without your signature. And obviously you make the arrangements that you get reimbursed for that lost material, lost time, whatever. So yeah, the builder's risk isn't a typical need unless the project is you know, obviously costly and there's a lot of money into it. But you might want to remind your customer that they should, and you can make the judgment, is this typically a maintenance kind of thing, or are you putting a 3-room addition on? You know, make sure that the customer either does have the builder's risk policy, or that they properly increase their homeowner's insurance to cover the cost of that project prior to the project start. And by the way, if you ever have a question about that, and you're not sure which way to go, or maybe how to advise your client, please feel free to call me.
Okay, thanks Don for that information. It's helpful, and hopefully the sound picked that up. That's some good advice relative to insurance coverage. On page 4, I'm going to just continue scrolling through the contract. There's a provision under section 10 for default prior to construction. Every once in a while we see a customer either get cold feet or something goes wrong with financing, and maybe it's a situation where a contract was signed and financing wasn't approved, but meanwhile the builder got a jump start on the project. This paragraph allows you to get paid for work you may have completed or materials you may have provided for a project. Section 11 is important. That's the lien notice, and it's all caps because that's what the statute requires. So that is pretty much verbatim out of the state statute, so we obviously recommend that we include those right in the contract document and make sure it stays in all capital letters. Section 12 is one of those very important provisions that's not only important from the psychological perspective of the customer, but also required by the administrative code, and that's the construction time. This is one of the big areas where we see concern from the customers in particular as a project goes along. They are always anxious to have the project done so they can, especially in remodeling, use the rest of their home or use an addition that's been added to the property. The most important thing is to have a start date and a completion date in the contract. Now that doesn't have to necessarily be a very specific date, such as June 1st and September 30th as start and completion dates. Those can be contingent upon various things. For example, in 12A, we have builder will commence work within X number of days, which you fill in the blank, after all of the following occur. This gives us some flexibility as far as the start date, and allows the builder to make sure that first the contract is signed, second that the down payment is made, and third that financing is secured, or otherwise, the money for the project is covered. Another aspect of that is the building permits and approvals are issued. That's also important, obviously, because if there's any delay in the building permit and getting started on a job, that could delay the completion, of course, of a project. Then substantial completion, we have got, and these are calendar days, not working days, so that's also important to keep in mind. That was a policy decision that our contract committee made at our last revision of the MBA of contract forms, is to take out working days, because that sometimes would confuse the customer, because obviously weekends and holidays would not be included as working days, and then there was some issue as to whether weather delays or weather days should be counted as working days. So to try to keep things clear and make it more concise and to help enforceability, we put in just regular calendar days. So sometimes we'll see, substantial completion will occur on or before 120 days after commencement of the work. That would be a bigger job, of course, subject to the terms of this contract. So again, the start and completion dates don't have to be specific dates. Sometimes you can assure the customer, if you're 99% sure, hey, we'll have somebody in there to start work before June 1st. But then you say, well, and then we need 90 days to finish your job. Hopefully we'll be done before then, but make sure the contract says 90 days, and you can assure them that you're going to be paying a lot of attention to their project. And because summer is a busy time, sometimes it may take 90 days to do, maybe a significant kitchen remodel, for example. Substantial completion is defined as a defined term, and it's defined in 12B mainly because that triggers an obligation for payments. Effectively, if the project is done where the owner can occupy the space, or essentially all permits or approvals are obtained, that triggers the duty of the customer to make payment, even if there's a punch list. So substantial completion does not mean that you're 100% necessarily done. Usually the intent is to allow for a punch list to be prepared and make sure payment is made, because in the past we have seen some customers say, well, you didn't bring this door handle, so I'm not going to give you the last $50,000 under the contract. So here, if substantial completion is done, they have to make that payment. You say, we'll get you the door handle, don't worry. So that's the reason why we have a definition of substantial completion. Construction delay is certainly one of the bigger psychological hurdles we see with remodeling and even new home construction, for that matter. There is a specific procedure we laid out in the contract under 12C where construction delay is covered. Essentially, if there's a delay for any particular reason, the builder is actually under the administrative code obligated to provide a separate notice of delay, it's called. And the MBA has a form for that. Usually what I recommend to my clients, though, and even though the form is there and it complies strictly with the ATCP 110, there's other ways of complying with the delay rules, and one of those is to either send an email or a letter that's nice and touch and feely, which goes back to the psychology aspect, telling the customer, hey, your cabinets were delayed by 30 days, which is going to push the project back 45 days possibly. But the key thing is to make sure the customer acknowledges that and basically agrees to that time frame, or understands that that's really the way it has to be, because you don't have the cabinets to put in. So I have a number of clients who do this all by email, and they write a nice email, but they do it in such a way that the customer must respond, and must respond in some affirmative way, that they acknowledge that, yes, I understand that the cabinets were delayed and that time frame is okay. So that's kind of one way of helping to smooth over delays in projects, which I think are typically kind of red flags for the customers, or they get worried. But a good approach is to try to smooth that over, even talk to them on the phone and say, hey, I'm just going to send you an email, could you respond to that email? And then again, combining psychology with compliance with the law. One other way of doing that is by a letter rather than this formal form. And then a third way of doing that is actually by a change order. If there's a change that will cause a delay to a job, let's say somebody upgrades instead of a Formica countertop, they want granite. And it's gonna take, 60 days to get the granite in. A change order is a perfect way of both accomplishing the increase in the price, but also letting the customer know that, hey, this project's gonna take us longer now. We told you 45 days in the contract, but this will take an extra 30 days. Spell that out in a change order so that you have the price covered and you have the increase of time covered in your change order. And that way, your rear end is covered under ATCP 110 as well as under the contract. Again, and especially if there's a cost increase. Oh, question?
If you could go back to A, the way the paragraph reads, it reads as though it's days rather than working days.
It's not working days, it's calendar days. So
So is that what you're recommending, rather than working days?
I don't mind working days in there as long as it's defined so that the customer understands that working days don't include weekends or holidays. And then if we're gonna go one step further, that working days don't include bad weather days. So that's where if there's, and even under ATCP 110, you might still want to put something in writing. Let's say we have a snowstorm that holds up a job for a week. I would put that in writing somehow, try to get the customer to acknowledge that, oh yeah, sorry, you can't make it because of a snowstorm or some other, weather situation. Or if it's a roofing project and there's an ice storm or some other weather pattern that holds up the job, that's where you can have working days in the contract and technically you'd be covered, but under the administrative code, you would also want to do one additional step and make sure the customer understands that even though you have your butt covered in the contract, but you still need to, under the administrative code, let them know that there's going to be an extra time because of this delay to finish the work.
Well, in the new construction contract, if I remember correctly, it is working days.
I think I'll have to double check that, but I thought that the committee, frankly, I was kind of on the fence about that, but I think the committee had changed everything to be uniform to working day, calendar days. And I'll make a note of that and double check that then. Bob?
If we get a customer who doesn't return change orders, okay, basically you send out a change order and you give them a date that it's supposed to be either accepted or declined. And then we put a phrase in there that says for every day that this isn't returned, we add 1 day to the length of the contract. Because technically we're sort of held up, we're fighting to keep the job going at the same, and then we're fighting the ATCP laws. So it's like, we're sort of building in that delay. And I thought that was okay.
I think that's okay to do that, but I think you also need to keep in mind though that that's not technically in compliance with the ATCP 110 because the rule under ATCP 110 says that the notice of delay and the agreement to extend the work must occur at the time of the delay. So if you do it at the beginning, there's that technical...
No, it's sort of included in a change order. That's what it says.
Well, if it's in a change order, then that should be okay.
Yeah, because in the change order it says, you got the date of the change order, and it says you got to return this change order within so many days, actually a date typically. And then a failure to do so will add 1 day for every day that it goes past the deadline.
As long as that's clearly drafted, that sounds pretty good. Because as long as it's in the change order and not in the contract itself, because that is signed kind of...
It's actually in both.
Yeah, because then that would be signed kind of at the same time as the delay, and if they're causing the delay by not getting you the change back right away, once they sign the change order and return it to you, I think that would be binding under the ATCP, and certainly it's binding for contract purposes. And I think there too, because of some of these new cases which have been helpful, it'd be really, a customer would be hard pressed to prove that they incurred damages because they delayed returning the change order, because really it's on them for not returning the change in a timely manner. But I like the idea of doing it in a change order as opposed to the original contract, because then that's closer to strict compliance with ATCP 110, which unfortunately is probably the best way to go, obviously. That's the best advice, is to comply with that. Yes?
In that case, could you assume that the customer doesn't want that change if he goes past the date?
I think you could do that, but I think I would also document that somehow, either in a letter, just saying, since we did not receive this back from you, and get it to the customer in some manner that you can prove that they received it. And emails, again, are good, and that's kind of been a very helpful tool for us in this day and age, is to confirm that while I was looking for that change order, I'm going to have to assume that you did not want that change, and so I'm going to move on and put in, let's use the countertop example. I'm just going to use the originally specified countertop rather than the one that you were thinking about using. So that makes sense. Just paper trail documentation is key in those examples. Yes?
Going back to the working days, why was the decision to go to calendar days versus defining what working days mean?
I think it was mainly just because theoretically everybody understands calendar days, and there was some confusion about what a working day is. And I think that, if you, and this would be a modification of the contract, and I didn't talk about changing the MBA form, but you're certainly entitled to change the MBA form. I would just be cautious then, because the one thing that I always tell my clients is if they want to use their own contract form or modify this document, that's great, but you really need to take the MBA logo off of it. You can say you're an MBA member and all that, but at the bottom it does say that this is the MBA Remodeling Construction Contract. So anytime there's a material change to the form, little changes are probably okay, but a change like that where it changes calendar days and working days, you just want to take that little blurb off, especially at the bottom. I mean, even the MBA logo at the top, I would probably say you could leave on there. I have had a case where somebody raised that, said, well, I thought this was a standard MBA form, and some judge gave that a little bit of lip service. Ultimately, we prevailed on that issue because it was such a minor technicality. But there have been cases where that is raised as an issue where people, on the other side of some of these things, we've got a lot of, I call them ambulance chasers in the construction industry, and they'll pick on every minor detail and try to make, a mountain out of it. So if you do that, I think that's great, and then just so that it's clear that working days are defined thus and so. So if that's your preference, certainly that makes sense to me to have that in there. Bob, did you have?
Yeah, one last question. So in our change orders, we typically put in, this change order will add so many days to the job. We fill in the dates. Now, do I still have to send out a delay notice if they sign that and they?
No, I would not use the notice of delay form. The notice of delay form that's available through the MBA forms, we developed because that's strict compliance with ATCP 110. But if you do everything by a change order, which is probably a little less alarming than a notice of delay, that's certainly fine. It's just that there's critical components to that. As I talked about before, if there's a price increase, that has to be clearly set forth in there. And then if there's a change in the completion date, or you could say, well, this will add 2 weeks to our completion date. Something so that it's very clear to the consumer or customer that there will be extra time needed to finish the job. So a change order is great because it's probably a little bit easier to work with the customer instead of having one more form that they might not be familiar with, that might be a little bit onerous or a little scary to them. Let's see. So I'm going to research that issue about calendar days too. I'll get back to it. But like I said, if you wanted to change that, you could certainly do that in your contract. And we do have clients who do modify the MBA form, and some that incorporate some of the key things, such as the allowance paragraph. I think we put a lot of time into defining what allowances are to try to make it clearer, I guess, to the consumer. Same with the changes. But one of the key things, though, too, is you must have the start time and the completion date in the contract. That is one of the biggest issues I've seen, where, especially with the the person who uses the one-page quote, sometimes they won't have the start date and the completion date, and they won't have some of the details, they won't have the lien notice or some of the other things that might actually be actionable under the administrative code. And I always recommend, of course, the detailed specifications to help, even if it's just a single sheet of paper or if it's some drawings. So make it all part of the contract documents so that expectations of the customer are clearly put down on paper and that they sign off on those. Let's see. Any questions, feel free to jump right in and raise your hand. Let's see. We have work stoppage and termination under 18 and 19 on page 7. That's one where some thought was given to, because in case a customer refuses or is unreasonable about making payment, 18 and 19 are designed to give the contractor some clout to try to keep the project moving. And going back to my prior comment that it's always better to finish a job, but hopefully section 18 and 19 won't have to be used, but there's some clout in there just in case the customer stops the job and is unreasonable about it. Section 20 is an important one. It talks about construction materials and substitutions. Substitutions is an important topic, and it's a little vague because the administrative code says there may be no substitution of materials unless the customer specifically signs off on that. Now I can understand that when it comes to like a plumbing fixture or a shower door or a countertop, where if you're going to replace one countertop with a different kind of countertop, definitely we want that in writing. But the code is broad enough to even cover if you change some of the basic materials that may not be even something the customer understands or knows about. So if you want to substitute a 2x6 wall in a spot on a project instead of a 2x4 wall, theoretically the administrative code says you have to get the customer to sign off on that. But I think substitution of materials, we did have one case where there was a substitution of a name brand, like a air conditioner furnace and air purifier, for a different name brand air furnace and purifier, and the customer, I think, might have been a little unreasonable, but Carrier versus one of the other brands was the issue in that case, and the contract specifically said Carrier, and they made a big deal out of it, and we ended up settling that case just by giving them a couple $1,000s to go away, because the cost of fighting an issue like that, frankly, is not always worth proving the point. Even though they were equal in quality and equal in reputation, the specific letter of the law is that you can't substitute Carrier or Moen and Kohler without having the customer sign off on it. So the substitution, I think, is important to, in case there are those things, it's just like a change, make sure it's in writing in one way, shape, or form. Now I know there is a new rule under ATCP 110, but where verbal change orders are acceptable. But again, there's this specific other aspect of that, is if the change order increases the total contract price, it must be in writing. So the best practice is to obviously get as much in writing as possible, be detailed, be specific, and make sure that the change orders are there for every, especially if there's a significant price increase, make sure the customer signs off on that, or at least do the email thing with all of the details in an email. We've got a number of other things, plans and specifications, section 21, that is pretty, I'm sure you all follow that. The more details, the better. I have seen contracts where it just says remodel a kitchen and install new cabinets, and those are nightmares, because then there's no specification, and sometimes they'll put a total price and say, well, you asked for a different cabinet, so the price went up. So more details, the better. There's a couple things toward the end here about dispute resolution. One of the things that's required actually under Wisconsin law is this notice of construction defects and right to cure. With every contract, there's the right to cure brochure, which is available through the MBA. That should be part of your contract documents at the time of signing. That informs the customer of the right to cure law under Wisconsin law. And the right to cure law is essentially a rule that says that the homeowner, if they discover a defect or a problem with the project, really needs to give the builder at least a chance to try to fix it or to make a suggestion to try to fix it. It's not as strong as I would like because it doesn't mandate repairs as the remedy. It just says you have to talk to the builder, and so at least that's something that it forces the customer to talk to the builder and say, hey, some door isn't closing correctly, so could you come back and take a look at it? So that's a rule of Wisconsin law, but in order for that to be binding, there is a brochure. It's like a 2-page handout that's available online either from the state, and I'm not sure if it's on our website, but that's something that should be part of your contract documents. Now, our standard form calls for mediation and arbitration, and we have, the MBA has got the mediation clause as being conducted through the MBA mediation service. That has been a pretty successful tool for dispute resolution, especially early on. So if there's, especially during a project, it's great if there's an impasse, let's say work is stopped. Mediation is a great way to try to keep the project moving and get things resolved. Now, arbitration is the next step. Arbitration is binding, whereas mediation is voluntary. So if you go into mediation and don't have a voluntary resolution, then the contract form calls for arbitration. And our MBA contract calls for arbitration here at the MBA, and that's pursuant to the MBA bylaws, which basically require all contractor members of the MBA, who are builder members, must have dispute resolution provision in their contracts, and calls for arbitration as the way that disputes get resolved. It doesn't necessarily have to be at the MBA, but we recommend that, and now that the MBA arbitration service has been renovated and retooled, I think it's a good way to go. Although I have on occasion had people use judges as mediators and arbitrators, retired judges who are no longer on the bench, but they too can serve as mediators and arbitrators outside of the MBA. One of the things that I see and get the most questions on are the indoor air quality. Oh, I see a typo. Well, we'll have to get in section 25 on page 10, quality is misspelled, but ultimately the indoor air quality goes back to newer, tighter construction methods where moisture gets more readily trapped in the home. Some of the bigger concerns there are bathrooms and kitchens, of course, but also just condensation on windows. Over the years, we heard more and more concerns and complaints about that. So this paragraph is designed to try to educate the customer that they have certain obligations to maintain, good airflow within the home. This was recently changed to try to make it a little more user-friendly, but frankly, there's still a lot of legalese in there, so that is sometimes a stumbling block when you're trying to explain to the customer what that means. Unless you have a lawyer in your back pocket, sometimes it's hard to explain. But essentially what the main purpose of that paragraph is to both educate the customer, but also protect the contractor, just because of if they don't use proper ventilation in the home, or somehow don't properly maintain the home, that they could have a moisture problem in particular. This paragraph also covers radon, where radon is not the builder's responsibility unless it's specifically made part of the contract. So I think those are two of the bigger reasons why we have that. Mold has been an issue in the past. I'm not seeing as many mold cases as we used to, thankfully, because people, I think, are more aware that modern construction methods do require extra ventilation, and we're seeing more things like whole house fans and other additions to the HVAC that help alleviate that problem. Now, particularly in remodeling, we have the unforeseen conditions aspect of things, and that is, and that's part of the provision on page 11, that should mold be discovered in a wall that gets opened up and needs to be remediated, unless that's specifically included in the contract price, that is basically the homeowner's responsibility, and unless the builder has actually caused the mold to occur, it's generally going to be the owner's responsibility to take care of remediation. Similarly, section 26 and 27 are designed to cover these types of things, although lead-based paint is kind of a creature unto itself, and for remodeling in particular, We do have to hand out those pamphlets, especially for houses that are built before 1978. So all of these environmental things and mold and lead and unforeseen conditions, for example. I know I had a remodeling job done at my house a few years ago, and we had discovered that there were a few unforeseen things, such as plumbing put in exterior walls, and in order to keep the pipes from freezing, the contractor just cut open a heat duct that was running in the same wall to try to take care of that, and we didn't like that. It was not necessarily the best practice. We also discovered some weird electrical issues where it was hard to figure out what happened, but a number of electrical lines kind of came together in one spot, were not to code, and there were just a number of ends of electrical lines that just were taped off and stuck in a wall and kind of tied up in a bundle, and that was probably not to code either. So sometimes, of course, as you know, in the industry, unforeseen things happen, but that is not necessarily the builder's responsibility. And here too, this is one of those important areas where it's critical that the customer understands that, hey, when I open up this wall, I'm not sure what's in there. Sometimes there's a structural problem where you need reinforcement. I had one case where there was a wood floor situation where some engineering was required because once some of the work started, the support below was not sufficient and the floor was not straight, and so they had to put in a couple extra beams in the basement on this house to make sure that the floor was level enough to put in a wood floor. So the customer had to understand in that case that, well, that was an extra expense, and we did get some engineering, and so my client was covered in that case and kind of held their hand through that process, and the customer was a good one in that case where they were understanding. They had expected, they knew there was a little floor dip, so they expected something. It just turned out to be a little bit more than they expected, but they were still good about it because they were educated at each step of the way. So those unforeseens, obviously, in remodeling are key. One thing that comes up once in a while is water quality and water supply. Oh, yes.
Brad, could you explain why Section 25 requires a signature and date of customer? No other part of the contract requires a special signature. Why does this?
In this section in particular, there's a release provision where customer releases all claims against the builder. And there's provisions under Wisconsin law and in the case law that it's better to have them sign twice, so they sign right where the release is in the form rather than just signing at the end, because sometimes a customer will claim, well, I didn't see that release, and that's for the air quality component, so that the customer releases the contractor for problems that stem from air quality that's beyond the accountability tied in with that. We see a few other things along the way. Signage in 29. Sometimes we added that because obviously if it's a bigger project and the builder wants to showcase this at some point, I would like to put a sign up and maybe even take photographs and allow it to be used on a website. Usually I stress is that we don't disclose the identity of the customer or their address unless they actually physically sign off on that. There's a few things at the end too. This notice of right of cancellation, that's a rule of consumer law that there has to be a right of cancellation. That's the 3-day cooling off period rule, if you will. And there are a couple of pages attached at the end. There's two of them actually, 16 and 17 of your contract. It's actually done on purpose because the statute requires that we give 2 notices to the customer. One, if they want to cancel, they return to you, and one they can keep. So that's why there's a page 16 and 17 of the document. So that's kind of ties in with paragraph 34 where we talk about the notice of right of cancellation. Similarly, we do have separate sign-offs for the lead-based paint and lead-based materials. There's 2 different sign-offs for that. So we're supposed to give those EPA brochures to the customer at the time the contract is signed, and then they sign off on that. Similarly, the right to cure or right to repair law stuff, That's in the middle of page 13, where Wisconsin's framework for successful communications between consumers and contractors. That's just the right to repair law and the right to cure brochure. And by signing that form, that just acknowledges that they've received these materials. And in order to make our contracts fully binding and compliant with some of the applicable rules of state law, that's why we have a number of different signatures, is so that we're crystal clear as to what they have received at the time the contract was signed. And we've put a Schedule A, a labor rate addendum. Bob, you have a question?
Yeah, can we get these brochures here?
I believe,
All electronic.
yeah, electronically, and then certainly on the EPA website, and then now it's DSS in Madison for the Right to Cure brochure is Department of Safety or something like that. It used to be, Health and Social Services, but now Governor Walker changed the name of the department. But if you look up Wisconsin Right to Cure brochure, it's going to be available. It's just a 2-page document, and we usually just print those off. And the other 2 are available on the EPA website. And then ideally, we would have a link here, and I'll check on that too. Okay, all right, thanks. I wanted to mention Schedule A specifically. That's a labor rate addendum. That ties in primarily to 2 different things. One, change orders, in case there's extra work required. Technically under ATCP 110, if a change is charged on a time and material basis, a labor rate has to be disclosed. That could either be done on a Schedule A, or it could be done in the change order itself. But it's important that the labor rate is disclosed, mainly because the ATCP requires it, but also because it educates the consumer as to what they can expect as far as the total cost for a change. The other reason that this Schedule A is attached is actually for the time and material or cost plus type contracts. So we made a list to try to help educate our membership really on what they would need to do, particularly if we do a change order that's a cost plus or a time and material, or if we do a complete cost plus contract. These are some of the main categories where there should be specific labor rates laid out. And then we also have attached the lien notice, and frankly I thought it was overkill, but I got outvoted at the committee level, so we have an extra piece of paper for you, where the lien notice is also an extra document in addition to being part of the contract. So we're kind of it's sort of belt and suspenders, but it's better to err on the side of caution, I suppose. So I think one other thing I wanted to mention too is at the outset of these projects, I'll go ahead.
Why again, is there 2 copies of the notice of right of cancellation?
That's required under the Consumer Act. You have to give them 2 copies. It's just this, that's what the statute says, so we are trying to comply with that. Because one, theoretically, the customer could return to you, and one they could keep. So that's a technical compliance with the state law on that subject. I did want to, go ahead.
Can you go back to page 14?
Sure.
That almost looks like where you put your allowance, total allowance for each item you're charging the customer, or you're putting that to the customer at the labor rate. It looks better than these.
Oh, yeah. Yeah, I think, well, the intent was for remodeling to have it serve as the hourly labor rate, but I see what you're saying is that it's, the allowances could cause some level of confusion there, so I think that's a good point. I think on a time and material type basis, I think you're right. There shouldn't really even be a total down there, because this is specifically designed to educate the customer as to the hourly rate. So I think I'll talk to Becky about making a change there. So thanks for catching that. But one other point I wanted to definitely emphasize is that we do have construction quality standards, and this is something that sometimes best to talk about with the customer ahead of time, because we keep seeing cases from time to time where the customer expects perfection, that everything is going to be lined up to some scientific crazy level of precision, But that's why industry standards have been developed. I think we borrowed from the National Association of Home Builders, and we have developed 2 different sets of rules, one for remodeling, one for new home construction. There's some discussion now about combining those into one set of industry standards for quality purposes. But those are basically the tolerances. These are kind of the minimum standards that contractors must follow. And I think it's important to educate the customers that, you know, the miter joints aren't going to be precisely tight, you know, so that you can't slide a piece of paper in there, for example. But at the same time, they have a certain right to expect quality, and that's where photographs of your work or the ability to show other projects is always helpful. But ultimately emphasizing to the customer that maybe not even saying that perfection cannot be achieved, but trying to educate them at the beginning of the project that this is not necessarily going to be you know, perfect in precision. There may be some things that are a millimeter off here and there, but that so that they understand that there are tolerances within which we operate in the construction industry. And at the end of the day, I think most of the customers get nervous along the way because if something is off a little bit or if there's a little gap somewhere. But at the end of the job, when they see the completed product, that's when they should be relieved and say, yeah, you know what, this looks really good. And while those can lights are, one of them is about 1 millimeter off in the row, it still looks great. So the assurance needs to come, I think, all the way through the job that at the end of this, you're going to be excited, you're going to be happy with the work, but it's not going to be precisely perfect. So that's where that's kind of the short version of trying to use psychology at each step of the way to make sure the customer understands that sometimes things are a little bit off, but that at the end of the project they'll be getting what they requested and it'll look great and they'll be very happy about it. So I think I sort of jump back a little bit back and forth between the key things, but I did want to emphasize in the presentation the components of Wisconsin law that govern remodeling practices in particular. And of course, it kind of starts with ATCP 110, which are the rules of the road for remodeling contracts and execution of projects. What we've done over the years is try to adapt those rules both into the industry standards for quality, but also into the contract documents so that if our membership uses our contract forms, they basically will be compliant with the technical requirements of ATCP 110 and not have to worry about it. And the other aspect I like to emphasize is the paper trail, whether it's by email, fax. I even mentioned text messages. I had that in one case where we printed off text messages and had to use it for a case. And that was binding. I had a judge uphold that. So anything you can do to create a paper trail is ultimately your best protection in working with your customers. So I think that as we go forward, you know, using the contract documents or some variation that hits on those key components that we talked about. I stress those in the outline that I passed out, so maybe take a look at that. Should you have any questions or follow-up, feel free to get a hold of me. I see Bob has a question.
Yeah, on larger projects that, you know, were major renovation projects, where they exceed the value or the assessed value,
Sure.
that ATCP law doesn't apply at all?
Yeah, that does not apply at all. That's correct.
Okay.
So if you're working on a home that has an assessed value of $150,000, and let's say it's a whole house remodel, that could easily exceed that $150,000. Then ATCP 110 does not apply, but psychologically you'll have the same concerns with the customer, so it's always good to follow those rules anyway. But at least it's less of a legal nightmare should an issue arise down the road. Did you have a question?
Actually, suggestion on page 11, having 2 customer signature lines rather than 1. And the same thing for the documentation acknowledgement on page 13.
Okay. Oh, that's a good idea. We should be able to get that in there and get those forms updated. I don't think I have any other thoughts or questions. Go ahead.
You had mentioned that the MBA does not want us to be making any changes to the contract and still calling it their contract. what's your suggestion, as we're working with a customer that hands this to their attorney, and their attorney wants to make changes to that contract?
Well, I can guarantee that their attorney will make changes, because that's what
I can guarantee
attorneys
it
do.
too, that's what I'm asking.
And my favorite story about that is I had Foley and Lardner take a look at one of our contracts. He came back to me, they completely rewrote the contract. So what I did is I completely rewrote it using their form, reincorporating all of our MBA stuff, and they approved it. And it's like, so I just changed the words to match his words, but it said what we wanted it to say. So you will definitely get that, and I still shake my head about that, but that's a different story. So ultimately, the concern there is that it's certainly appropriate to modify the MBA form. It's just that it's important though from, just because of some of the judges and some of the decisions that we see over the years, that if the form is changed, a judge doesn't want to see the MBA butterfly in the bottom or bumblebee in the bottom, whatever you want to call it. So I would just delete that with the copyright 2017, because that indicates that it's a precise copy of our MBA form. So we could take that off, and I've had some contracts where I've actually added a clause that says this is based upon the MBA standard form, but it contains different terms and conditions from the standard MBA contract. And that's the ultimate way to kind of cover our rear ends, is by putting a sentence in that says that this is based upon the MBA contract, but it does not precisely copy it or reflect it.
So the MBA is okay, even though they've copyrighted this, that we use it in a changed form and take their copyright off?
Yeah, absolutely. I'll ask Chris about that later.
Yeah.
But no, that's one thing we have talked about in the past, and that I'm comfortable saying that you can certainly do that. It's just that it's really for your protection, that a customer can't come back later on and say, well, you misled me, because I thought this was the standard MBA form, so I didn't read it carefully. And that creates a can of worms. So we're trying to minimize your headaches by having you do that. Yes, sir.
For real small projects, and this is a, 17-page document. The MBA had a home improvement contract, is that still usable? Like, let's just say you're just changing out a door in a customer's
Yeah,
home or
no,
something.
that home improvement contract still works. It's a form we just revised last year. It's available on the website. I've actually had some of my clients come to me and say, hey, can you shorten this up too? And we've been able to do that. And I think, as I mentioned before, as an attorney, it's impossible for me to write a 2-page contract. But a 20-page contract is a piece of cake. But ultimately, what I've done in a couple of, we've gotten them narrowed down to focus on the critical components of ATCP 110, which are the start and completion date, the price, or how price will be calculated, the terms and conditions or scope of work. And if you have that in there, I think you're 99% of the way home in most cases. But then I also like to get in there the changes, some language about what a change is, and then allowances too. If there's allowances, that's one of the bigger areas I've seen over the years. So those categories are really the critical ones in my mind. Other attorneys might disagree, but that's just kind of based on my experience and what I've seen over the years, is if you can narrow down your document, and certainly a customer with a small job doesn't want to see a 17-page contract, and you don't want to sit there and say, well, the MBA told me I should use this form. But the home improvement contract is helpful because that's shorter. And there's, like I mentioned, if you have those critical terms in there, those are the ones we see in litigation. Those are the ones I read in the case law. It's the start and completion date, the price, or how the price will be calculated, and then the specific scope of work, what's included. So if you have detailed specifications for a job, say you're going to get cabinets from Drexel in this color, this quantity, this cabinet or this style of countertop, here's your hardware or the hardware allowance. So just so all those things are clear, that's really the main package. The rest of this is great from the legal perspective, but I know out in the field and as a practical matter, it's kind of tough to explain to a client the lengthy terms and conditions. But again, for any larger job, this contract is important because I think it covers a lot of the contingencies that we sometimes see, unfortunately, on the other end. If a problem comes up, then if the more detail in the contract, the better. But for a small job, I totally see your point, and I would use that home improvement form. If there are no other questions, I think we'll adjourn for today. I really appreciate it.